Okay, hi everyone. Thanks so much for joining us today. We're going to go ahead and get started now. And my name is Megan Bruce. I'm the Online Communications Manager here at Juvenile Law Center. So thank you again for joining us for today's webinar on transition planning for youth with disabilities in the child welfare and juvenile justice systems. In case you're not familiar with Juvenile Law Center, we're a nonprofit public interest law firm, and we work nationally to enforce and promote the rights and well-being of youth in the child welfare and justice systems. Our strategies include litigation, appellate advocacy, and submission of amicus front of the court briefs, policy reform, public education, training through webinars like these, and strategic communications. And you can always learn more about us on our website, jlc.org, and we have tons of resources on there as well. So before we get started today, I just wanted to run through a few technical issues. If you're participating by phone today, your line will be muted during the entire webinar. If you have any questions during the webinar, you can type those into the questions box, and that appears on your GoToWebinar control panel, which is that long rectangle on the right side of your screen. And there's a little orange arrow there at the top of that rectangle, so you can click that at any time to expand and collapse the control panel. We'll make an effort to address your questions as they come up during the webinar, and we'll also try to save some time at the end of the webinar to address anything that we might have missed. And just a note that all the materials that you'll see today during this webinar, including the PowerPoint and the tools that we'll be discussing, those will be sent to you after the webinar. You'll receive a follow-up email tomorrow with all of that information, so don't worry about not having that. We're also recording today's webinar, and that will also be available for viewing on our website, and you'll receive that link tomorrow as well. And finally, today's webinar is a high-level overview of transition planning for youth with disabilities. We'll also be launching a lunch webinar series in 2014 that will explore in more detail different aspects of transition planning for youth with disabilities, like effectively using SSI for youth in care and upon transition, and educational transition planning for high school and college. So we'll be providing some more information about that webinar series at the end of today's webinar. And now I'd like to turn it over to today's presenter. That's Jenny Pokempner. She's a supervising attorney here at Juvenile Law Center.
All right, good afternoon, everyone. Thanks for coming out in the snow. Hope everyone is safe at their offices or at home. And again, thanks for joining. I recognize a lot of names, so I'm really excited that people are interested in this issue. And as Megan said, this will be kind of our first of many webinars that we'll be doing in 2014 to work on the issue of transition planning for youth with disabilities from the child welfare and juvenile justice system. Our goals for today are really to review the laws and regulations that do regulate the provision of treatment and service and transition planning for youth in the child welfare and juvenile justice system. So you have some of the legal tools to advocate for the youth you're working with. I know we have a lot of different stakeholders here today, so both people who are working with youth directly providing services, case managers, as well as attorneys. So hoping that this will be useful for everyone, even if you might use it in different ways. We're going to try to review strategies for improving treatment and service for planning while youth are in the system. I think most of us really believe that one of the ways you improve the transition for kids as they're aging out is really to improve and be really aware of what they're receiving in terms of treatment and service while they're in the system, so they're in the better position to transition. And then reviewing action steps for really ensuring that that transition from the child serving to adult serving systems is done in an appropriate way so that the youth transitions as seamlessly as possible. And then we want to go through some of the tools that Megan mentioned are already on our website, and many of you might have the tools already, but we'll definitely kind of explore how to use them and then how you guys can access those. And as Megan said, we're going to be hosting some monthly webinars. At the end, I'm going to show you kind of the specific details of what the topics are. We have about 10 to 12 planned because a lot of these issues are really complicated. We'll just be kind of touching the surface today. So please know if you feel like things weren't gone into in enough detail, we'll have an opportunity to go through those. And we're also hoping that those webinars, there'll be a little more opportunity for feedback and discussion. The limitations of having the webinars that we don't get as much feedback from you guys on the other end. The benefit is we get a larger audience throughout the state. People don't need to travel, and hopefully this is convenient for people, but I know you do lose some of that direct interaction. As Megan, though, did say, please do be chatting in or sending in questions as you think of them. Even if we can't get them, it'll be helpful to have them, and I'll try to address them as quickly as possible and as we go over the topics. I want to quickly show you two of the tools that we're going to be looking at and that will be available to you. And, oops, I'm sorry. The first is what we're calling a planning tool and protocol. And I'm going to point to certain pages of this tool as we go through. But the goal of this tool, and this is a web-based tool that you can download from our website and that we'll send to you, and that you can fill out online so that you can be adding information as you're planning for a youth. It's divided into two sections. Questions that you'd ask in planning issues for kids 14 to 17 and then 18 to 21. And the goal of this tool is really to have it in a lot of ways be guiding your use of the professional's guide that I'm going to show you in a second. And basically, again, the goal was to ask you questions in your case planning that would prompt you either to take an action step or realize you need to find out more information of how to do things. Because as I said, a lot of these transition issues are complicated, and I don't think the expectation is that everyone become an expert. I think the expectation is that you know what are the key issues and the key decision points and times you need to make them, and who you need to have in your corner as a go-to for resources. And that's what this planning tool hopes to help you do, and that it would send you to sections of the manual. So here's the table of contents for the manual. So this is our transition planning for youth with disabilities from the child welfare system to adulthood, and this is the professional's guide. And this, we're going to go through some sections, or just point to some sections, is really divided in the same way as the planning tool. It addresses some of the issues you would be dealing with while the youth is in the system, and then it would more directly target in section 2 the issues you have to address when the transition is imminent and you need to figure out what action steps need to occur. I will also say the title of this guide has focused on the child welfare system. This webinar today, we are really going to be looking at these issues for youth who are transitioning from the juvenile justice as well as child welfare system. Most of the issues and laws that we would use are the same. When they are different, because there are some issues and some laws that specifically address youth in the child welfare and the dependency system, I will point those out to you. But most of the things that we are talking about really will apply to youth in both systems, which is a good thing, because I do think that they really are addressing the same problems and issues, so that that is something we want to have tools for both. So I'm going to go back in to the PowerPoint and just begin, but just wanted to point out those two tools. Okay, so the reason that we started working on this issue was for reasons that you guys are probably interested in this issue, is that kids that are in both systems, there really is an overrepresentation of kids who have both physical health, developmental, and mental health impairments, and that they are overrepresented in the child welfare and juvenile justice system for various reasons. So they are a larger population of youth we'd be working with proportionally, and the transition becomes an important issue because we do know that while our numbers of kids in the child welfare system and even juvenile justice system are decreasing overall to some degree, the proportion that are older is growing. And so the transition issue and the disability issue are one that we all have to deal with if we're working in these two systems. It also is pretty clear that at least from the research that we have, that kids that have disabilities and special needs fare even worse than their peers in these child serving systems. And so that also means they merit some special attention because they seem to be more vulnerable to some bad outcomes. And we know that it's challenging, the transition is challenging even for youth in these systems that don't have disabilities, so that there are some areas where we have to pay special attention for youth who do have disabilities. So some of the barriers that we tend to face, and I know this is kind of silly to bring up because we all know and there are these barriers, and that's why you're probably on this webinar, are lack of appropriate placements and settings and services for kids with special needs in both systems, and lack of appropriate or enough appropriate services for transition age youth. We have a lot of services that for kids and then for adults, and not a lot or as much as we want in terms of that transition age, where there are a lot of really distinct and unique issues. Another barrier to successful transitions is really just a lack of understanding of the adult serving system, and this is one we all deal with. Most of us work in the child serving systems, and maybe we deal with the adult serving systems when we're working with parents, but just don't have as much knowledge of it, and the rules and the requirements are very different. And again, you know, what I think people working with young people need to know is some of the key issues and make connections with those systems. We don't need to know everything about those systems, but we need to know some key portions, some key information, so that we can make the connections we need. So that is one of the goals of this webinar today and of the two resources we're presenting. And then I think what we all address in our various counties is kind of a lack of clarity of who's responsible for arranging services and supports as a youth transitions. Sometimes it's clear, and hopefully there will be people on the call who will say, I know exactly who does this. We have a clear system in our county, and that's something that I'd love to hear about, and I think we'd love to highlight, but is something I think that many of us still struggle with, of what exactly is the process and who is responsible. And so these are the things we want to attack both in this webinar and then in the webinars going forward, is how to provide advocacy strategies and information to attack those first two bullets. How do we advocate for more appropriate placements for our clients and youth we're working with, and develop the capacity of providers to provide it? And then how do we, and we want to help provide that understanding of the adult serving systems, both by the information we're providing, but also through these webinars where we're going to bring in experts from these adult serving systems. And then also we do hope that this webinar and the work going forward motivates you all in your respective counties to be organizing within your counties to figure out, if we don't have a clear system for how this works, let's create it. And figuring out ways you guys can do it in your own counties that make sense and work for you. So those are the goals. Okay, so to start with some good news, we actually do have a lot of really good laws, regulations, and court rules that really do support good treatment, and treatment that's individualized and appropriate for the kids we're working with. One of the issues that we do face is just enforcement, and really all of us using and marshaling those laws, both to create better services and advocate for them. So in some situations for youth to benefit from those good laws, we really do need to be requesting court orders, putting on hearings, appealing and litigating issues, and that's one thing our office can help with, knowing that everyone has a very heavy caseload. So the next couple of slides that I'm not going to go through each one is just giving you a sampling of the types of laws that we have in place that really do support both tracking, monitoring, and meeting the health care and disability needs of kids in both systems. And that's supported both in federal and state law. And so these are just giving you some of the details of the specific provisions you can use, both as a lawyer advocating in court, but also for you guys who are making the policy in your agency and are working with caseworkers, are saying this is what we need to do because the law says we need to do this. So if you are someone who's looking for what is the authority for the things I want to do, the next couple of slides are going to help you with that. And going back to, again, to be looking at how we use this planning tool. If you look at the table of contents for the professional's guide, it really is the first, thank you, Megan. I'm trying to move the screen up, so I apologize, everyone. That it is this first section of, went a little too far. The first section, section 1, where we really do go through most of the, thanks Megan, that's good, where we do go through most of the laws that do support monitoring health, both in terms of at a systemic level through the state, but also the responsibilities of the child welfare system to meet the health care needs, and then for the court to make findings with respect to health care needs, as well as some of the other important laws that I think will be helpful for advocates in terms of supporting meeting transition planning needs, independent living service needs at 16, as well as some of the educational needs. And then what is really important is this entitlement under our Medicaid law, and we tend to refer to Medicaid in Pennsylvania as medical assistance, the EPSDT requirement, which really does provide very comprehensive medical and treatment services for youth until they turn 21. But sometimes we do need to appeal denials of service, but it is a very strong law and is a great tool to make sure kids are getting the services they need. One other kind of new law I do want to point out in the webinar is going to take effect in January, and it is, and many of you have probably heard of it, in the Affordable Care Act. It did contain a provision that youth who were in foster care at age 18 and enrolled in Medicaid or medical assistance at that time are categorically eligible for medical assistance until they turn age 26. So there's still some work that needs to be done and some guidance from the state about how all of that is going to work, but they are working on that, and I think guidance will be provided soon. What I am recommending just as an attorney for kids is that if you are in court and we don't have guidance yet on what how this provision is going to be implemented, is that you do get in a court order this type of language that's on this slide, so that if the youth does need to go and apply for Medicaid, that they would be able to take a piece of paper that helps them establish eligibility. There's other ways that counties might have thought about doing that, and I definitely encourage, again, coming up with any processes that you think would work, but this is just one thing that lawyers might want to think about as your client is aging out, that you make sure the court order contains this language so that they can ensure that they can establish their eligibility. But knowing that these youth will have insurance until 26 is really important and great for the transition. And this applies to kids who have disabilities, but it also applies to your other clients. So that is something I definitely did want to point out because it is new and very exciting. One other provision, or a couple of provisions of these two laws, the American with Disabilities Act and Rehabilitation Act, are really important, I think, to youth in care and give us another tool and also some allies to help us with advocacy. While they are most known for just prohibitions on disability discrimination, what that looks like in terms of actions and in terms of litigation is also requirements that individuals be served in the most integrative community setting to meet their needs. And that is important for youth in care as well as adults. And the federal laws do require that every state have a protection and advocacy agency that can assist individuals with disabilities either advocate for themselves or get more information. And in Pennsylvania, the Disabilities Rights Network is our protection and advocacy agency, and I think some of you on the call, I'm sure, have worked with them and know that they can work with you if you're working with a kid in the child welfare or juvenile justice system. That's something they're very equipped to do and often can really help in getting services for youth and making sure youth are in the right settings. Because as you all know, we do have under child welfare law this mandate for youth to be in the least restrictive setting, and we usually think about that in terms of permanency and moving towards permanency, and that is very important. But it's also helpful to know that kind of in terms of treatment and treatment settings, you also have the legal support of the ADA and Rehabilitation Act to support less restriction for your client and figuring out how to get them in a setting where their needs can be met but where they have access to the community as well. Okay. Megan, I'm having a little trouble moving the slide. Okay. Thanks. So the transition planning obligation under the law is a really important one, and one I think many of you who are on the call who do a lot of work with independent living and transition planning already know. But what is important, many of you are familiar with the Fostering Connections transition planning requirement, is that we have very strong court rules that really specify in much more detail than the federal law what needs to happen before a youth child welfare case can be closed. And this Juvenile Court Rule 613 is specific to kids in the dependency system because it's related to dependency jurisdiction, but would apply to a youth with dual jurisdiction. So as long as there's dependency jurisdiction involved, Rule 1613 would apply. But it really does require that a transition plan, a discharge plan be presented to the court and that it be acceptable. And among the elements is health care, decision-making, and health insurance. And the rules do require and give you that tool that if the plan isn't presented that's adequate, the case can't be closed. And that is a rule that really supports making sure that planning is appropriately done, and it gives you some leverage to either order additional services or order that a planning meeting be held. And those cases are cases that hopefully people are using the rule and litigating it when they feel that it's not being enforced. So it's just an important rule to be aware of. Okay. All right. And then I did want to point out one of the things that I think many of us in Pennsylvania take for granted is something that is a really good thing. We have pretty good court rules, and one of the court rules, and this does apply to kids in the dependency and delinquency system, is that the court needs to make findings necessary to identify, monitor, and address the child's needs concerning health care and disability. And this is a rule we all should be using for the youth we're working with special needs for a lot of different reasons, but it does give us, again, some leverage in court and also make a record if we do need to advocate for more extensive services. And that rule also provides that the court can authorize evaluations and treatment if that is necessary. The other thing that I think is really important and that sometimes I think I myself take for granted is that we have really, really good case law in Pennsylvania on interpreting our Juvenile Act and the plenary jurisdiction of the court to order dispositions that meet a child's needs. And several of the cases that probably are familiar to many of you really do involve youth with special needs. So what we are providing is, and again, these are cases that I'm sure you guys are very aware of, a couple of cases that really do support the proposition that the court has the authority to order services if they aren't being provided already that meet a child's needs. And many of you are familiar with Tamika M. And that is a case that really stands for that proposition using 6351 and 6301 of the Juvenile Act. But Tamika M. did involve a youth providing services for a youth with special needs. We also summarize in this little sheet 2 other cases, Frederick F. and Janet D. And those cases are helpful if you want to take a look at them because they support that same proposition, but they also both involve cases with teenagers with very special needs. Tamika M. involved a younger child, still helpful and same proposition, but Janet D. and Frederick F really do kind of give you some of the examples of cases where it really was a teen and there was acknowledgement by the court that these are difficult cases, particularly with teenagers and complicated needs, but that there still is this authority and it's really limited by the child's needs. So just a reminder, and we'll provide the summary if it's helpful for people. Okay. So now we want to jump to kind of just looking at some of the things you might want to do to make sure kids' needs are met while they're in the system. And we want to start with this first poll. And the question that we're asking you guys on the line is, in your experience, how can the extension of care past age 18 help promote a positive transition for youth with disabilities? And Megan's going to launch a poll for you all to take. So if you could just give us your thoughts. Okay, so thanks everyone for answering the poll. So it looks like the majority of you said all of the above, and we thought we'd start with an easy one, although it's not so easy. Yeah, I mean, one of the reasons that having more time in care can be particularly important for youth with disabilities is for all these reasons. We know from data that more time in care tends to produce better health and educational outcomes for all youth, and that probably is even more the case for a youth with disabilities. The allowing more time to arrange for services sounds like it might be silly, but a lot of the services we're going to discuss about the transition really do take a lot of time to arrange, and there are more waiting lists. So in a lot of ways, having more time is really essential to the transition for kids who need services or significant services in particular in the adult system. And that time is time you need to plan, but again, it is also time to deal with some of the demands and kind of restrictions that the adult service system might have that you are forced to deal with if you want to be able to access services. And then again, you know, we know that the 18 to 21 age group, and for many of us, we'd probably say the 18 to 26 or 27 age group, that is a difficult time to figure out and be completely on your own. And these systems are very complicated, and so having more time can help prepare the youth to feel empowered and understand how to navigate these complicated systems. And the other thing to consider is that while kids at 18 are adults and they can get some services from the adult service system, as we'll discuss, there are some obligations that the child welfare system has that I think we all value and think are really important that they won't get. So there's not going to be kind of some legal responsibility to provide permanency services or look for family. Hopefully service providers are doing that, but we have in our law, our federal and state law, a really strong mandate to do that. And then things like court oversight and then the right to an attorney and that advocacy, those are things that go as well that are important to making sure some things are in place for young people. And as we do know, and is in one of the previous slides, is that our new law, Act 91, which does allow youth to stay in care until 21, one of the criteria for eligibility would be that they have a disability, a medical or behavioral health disability that prevents them from meeting those other activity requirements related to school and work. And so that law did envision that extension of care could accommodate youth with disabilities, with meeting the requirements, of course. And for most of those youth who have disabilities, they are engaged in the other activity requirements as well. But it is to say that there was thought that youth with disabilities might need that time as well. Okay. Okay, so just going to do just a couple of minutes on some of the strategies to kind of improve treatment while kids are in the system. This concept of least restrictive setting, I know, is something everyone is aware of, and I don't want to harp on it too much, but I think we've seen in our experience in working with kids with disabilities that this is one of the most important areas that we really need to be vigilant about and be really advocating for placement step-downs and really understanding that we can combine services and supports for kids to step down, even though sometimes it does take a lot of advocacy to do so. The least restriction, again, it's really important in terms of achieving permanency and putting youth in settings where they can make those connections with adults who would be lifelong supports or family, but also for kids who are entering adulthood. Being exposed to the community and developing those independent living skills and practicing those things are really, really essential. So it is an important thing to be focusing on. And so here are some of the questions and some of the things that we kind of recommend as strategies to how you would get to how do I get a youth in a less restrictive setting. Because it's one thing to say, yes, I acknowledge that where the youth is too restrictive, but it's another thing to figure out what would be the alternative. So one of the things to start with is looking at, are they getting all the services they're entitled to? So are they getting all that they need under their health insurance? As mentioned in a previous slide, under EPSDT, a youth should get everything that is considered medically necessary, but sometimes services are denied and you need to appeal them. And I'll give you some resources on how you can help doing those appeals. Because we have seen scenarios, for example, where a reason for a youth being in a more restrictive institutional setting is they'll say, well, MA won't approve nursing services if they move to a foster home. Now that is something that you can probably appeal, and we've seen examples of where advocates have won to say, yes, if it's medically necessary, it can be provided in the foster home. So looking at really what they need and what they're getting and the location is an important aspect. Also, providing permanency services. Even if a youth is in the most restrictive setting, they should be getting all the permanency service, family finding, they're interested in adoption, all those services, and those services can potentially help open up living arrangements where you could put services that could help a youth. Youth with disabilities are also entitled to all the child welfare services that any non-disabled youth would be, so independent living services and transition services. And that's the case regardless of where they're placed. And making sure that your clients or youth you're working with have those things is helpful for getting them to the point where they might be able to be stepped down. And then education. Megan is going to talk about, we've advertised another webinar that Kate Burdick from my office and Mara McInerney from Education Law Center will be doing next week about education and youth in care and in the juvenile justice system. But this is a really important thing for youth, I think especially for youth with disabilities, to understand that they have a right, regardless of their special needs, to be in the public school, even with an IEP with supports. They have the right to attend until 21, and that they do have a right to a good IEP, which includes transition services. So we're going to talk a little bit about transition services, so we have this next poll for you. So, you know, the term transition is something we talk about a lot, and it has its place in our child welfare laws in terms of discharge planning. We talked about the Fostering Connections transition planning. We also have transition services that are must be provided for youth who have special education services under the IEP. So we want to ask you about transition services in the IEP, and if you can quickly take that poll. Okay, thanks. Thanks, everyone. So it looks like the majority did check transition services include array of services and community experiences. And you know, this was a hard multiple choice question, so I'm not surprised that the answers are kind of spread out, because it does kind of show, I think, what often we're up against in doing a good transition plan for the IEP. But I think this 85% shows and is correct to say that what can be provided and what should be provided in the transition plan in the IEP is really quite comprehensive, and not just for kids in care in the delinquency system. I think our friends at ELC and DRN will concur that uniformly the transition plan is underutilized. I think why it's so important for us working with kids in the child welfare and juvenile justice system is that it is really a great place to really access really important services that the youth we're working with may not have as much experience with and access to in their placements, so that it becomes a really vital source and an important source for us to really enhance the services that we can provide to youth. Megan, can we go back to the slides? Thank you. Okay. So looking at what is required in transition planning. So transition planning for youth with special education services must begin at 14 in Pennsylvania. So that's better than federal law, which gives the 16. So Pennsylvania's decided to start earlier. It must be informed by age-appropriate transition assessments. In the professional's guide, around page 49. We have a lot of detail on transition planning in the IEP, both to give you some ideas of what are transition assessments, just so you can check if you're told an assessment is done, that you have some sense that the youth was given kind of appropriate assessments and not just an interest inventory. Interest inventories are really good and really important, but there's a lot more assessments that can be done, and assessments that can give you a lot more information both about the youth's talents and skills, but also areas of need, so that you really can develop the best transition plan. So that is one area to you know, just if you can look and read a little more up on, and also can consult with Education Law Center, us, and DRN on looking at those assessments. And then what must be provided in the transition plan and the services, again, is pretty comprehensive. It's not just academic skills. You know, you want to have your goals related to post-secondary education and training and employment, but also skills around independent and community living, things like transportation, things like getting around in the community, keeping doctor's appointments. all the daily living skills that youth need. And while a lot of these skills are skills that the independent living services and programs should be providing as well, I think one of the real benefits and assets of having it in the schools is that they're able to receive it more long-term and more consistently, and be able to practice these skills both in school but also in the community. And so also the plan should include community participation. So again, if that's an area where you feel in your program you haven't been able to give as much attention to, that those are things that can be in the IEP and the transition plan. Access to community activities, recreational activities, things that help develop skills that youth really need to be on their own as an adult in the community. And also the importance of having goals about adult services connections. So again, if that's an area where you need the collaboration and expertise of the school to do, that is something that can be in the transition plan. Again, in the professionals guide on page 49, we give some examples of what transition plans really could look like, and breaking down some goals for you, because I think what can be really surprising when you look at what can be in a transition plan is really how many creative services and how creative you can get. So page 49 to 50, we give you some examples that we've gotten from colleagues about goals they put in and the specific services to meet the goals. And I think I've been surprised of, gosh, I didn't know you could put all these things in the IEP, but these are exactly the kinds of things we should be thinking about. And so they do, even though doing this educational advocacy does take time and some investment, I think the bang you get from investing in getting a good IEP with these good transition services can really make a huge difference in the results you get and the readiness of the youth for transition. Okay. Okay, thank you, Megan. All right. Okay, and what Kate and Mara will, among many of the helpful things Kate and Mara will talk about, is going to be about, I think, education decision makers. But one thing that we found in some of the work we've been doing with kids who are transitioning is often we'll be reviewing a case with someone, and people will realize kind of late in the game that there wasn't an education decision maker. And so either there's no signature on the IEP, or a caseworker has been signing. And we know that that's not something, the caseworker can't be the educational decision maker, and you need a decision maker. And so now there are new court rules that allow the court to appoint. There's also some obligations that the school has to appoint as well. But that training, we'll talk more about that, and then the professionals guide has more details. But one of the things I think when you're thinking about educational services for transition age youth is one of the first things that they have in IEP you need to think about is who is the decision maker. Is the parent involved? And there's a lot of guidance and rules around this, but figuring that out, because if you don't have the decision maker, if the IEP isn't right, if you don't have the transition plan you want, you need the decision maker to be enforcing and asserting those rights. So that's just something to be aware of. One of the webinars we're going to be doing, but just wanted to point this out to people, is that one of the reasons we really do stress utilizing the special education system in the IDEA is that it does provide pretty comprehensive services, and youth can attend school until 21, or the school year in which they turn 21, and get all these services under the IDEA. But those end after high school, and so what we've got in college and training, post-secondary training, is not the IDEA. We don't have that anymore. What we have is the ADA and the Rehabilitation Act, and we have things called accommodations plans. And that summary of academic achievement and functional performance is something that needs to be created before a youth with special education needs graduates, and that can be used to help create an accommodations plan. But what you want to be thinking about as a youth is leaving high school is putting together the information you need so that you can do a good accommodations plan. But it is important to know that the IDA does not does not stay with a youth after high school. Okay. And then some other resources just to consult the Office of Vocational Rehabilitation on post-secondary options as well. And that I know people have had varying success with. One of the things that is important to know, and we have the information in the professionals guide, is that one of the federal agencies that need to provide advocacy for individuals with disabilities provides advocacy with respect to OVR. And in Pennsylvania, it's the Client Assistance Program, the CAP program. So if you are having challenges accessing OVR services for transitioning youth, the CAP program is a great resource, as well as DRN in our office. But they really can help you navigate and figure out what OVR can provide to a transitioning youth and help access those things. Okay. The other thing, before we leave kind of treatment in the system, that I think is just important to note is often we all do work with youth where they're just not making progress and they're not really flourishing, and everyone honestly is getting frustrated. And a lot of times the word that's used is that the youth is non-compliant. And I think just one thing, again, this is maybe more personal to our experience here at Juvenile Law Center, is asking, as soon as someone's saying the youth isn't making progress, that they're non-compliant, that we're really looking at if the treatment fits their needs. Because sometimes it doesn't, and sometimes the disability hasn't been recognized. We recently worked on a case where the youth had some learning disorders as well as a mental health, behavioral health impairment, and the form of treatment wasn't working for them because they had an undiagnosed learning disorder that was making the form of treatment just really not effective for them because of the way they learned and because of the problems they had with kind of understanding and utilizing kind of some verbal skills. So I do think it's important to ask these questions, and they're hard questions because sometimes you know a treatment doesn't work but you don't know what the alternative is. But again, I think it is important because I think the word non-compliance is used too easily for teenagers, and sometimes we do have to dig deeper and say, is the youth not non-compliant for what reason? And sometimes it's we need to look at something else. And sometimes it's because the provider may not and needs additional training on working with a youth with a particular disability, because some of these disabilities are very complicated. So that's not a criticism of the provider. It's really just an acknowledgement that capacity might need to be built in a certain area. Okay, so a lot of what I've said is easier said than done. I've said a couple times it's a lot easier to tell that something's not the right thing and a lot harder to find the alternatives. So here are some of the resources if you are struggling with this question. These are some agencies, and in the Professionals Guide on page 4 and page 30 we have a lot of the websites and contact numbers for these agencies. Disabilities Rights Network Health Law Project can give us, you guys, a lot of information about what are the right medical and health, behavioral health services a youth should be receiving, and also help with appealing denials of services. Every managed care organization has a special needs unit, and they can be a really great resource for information, both in terms of understanding the services available and also sometimes navigating kind of denials and figuring out what provider is the right fit. Education Law Center is a great resource for really making sure kids in both systems, both child serving systems, have the right and the best educational services. And then we have these other agencies like ARC, Mental Health Association, Center for Independent Living, and Liberty Resources. Again, as I said, there's more explanation of what these agencies are and how they can help you. But I think many of these agencies are seen as agencies that help adults, and most of them, if not all of them, have a mandate to work with youth as well, and can be a really great resource both of information but also of advocacy. Okay, so now we're going to jump to the transition itself. I want to start with this poll, and this is just from your perspective. In your county, the following is the main entity responsible for making sure youth with special health and other behavioral health needs are planned for. Okay, thanks, Megan. So it looks like almost half, about 45%, say the Child Welfare Juvenile Justice Agency, 17% the provider of the service, and then 38% it's not always clear to me. And I think this poll reflects kind of what I've gotten as the sense from people throughout the state, that we do know that the Child Welfare Agency and the Juvenile Justice Agency are ultimately legally responsible for the planning, but that in terms of what happens with this transition issue when these other systems are involved, that it isn't always clear to people. And so one of the things, again, we're hoping is that this does kind of motivate people to say, like, we've got to work within our county to figure out what system we want to create. I will note, and I think some of the people on the call might be participating in, DPW has convened a state work group to talk about and try to make recommendations around policies and practices for youth with health care and other special needs, and one of the subgroups is dealing with this transition issue. So I think the state is aware of a need for, I don't want to speak for them, but that group does really indicate that they want to think more systemically about this. I think in the meantime, counties thinking about how they want to structure things, I think will be helpful, and also will help in making things more smooth in your individual cases. But I think this does reflect where we are right now and the work we need to do. So I want to talk a little bit about some of the differences between the child serving and adult serving systems. Okay, so this slide just gives you a little snapshot of some of the key differences, and then we're going to talk a little bit more about how to address the problems that relate to these differences. So many of the services that youth receive are either mandated or considered entitlements. And so things like the EPSDT requirement, special education services under the IDA, and many of the services under the child welfare system are mandated. Very few services in the adult system are mandated or entitlements. Often they run in the form of you establish eligibility and then you hopefully will access the services, but that there are a lot more rules and waiting lists, and not so much as soon as you establish eligibility you immediately will be able to access services. And that's just important to understand the importance of planning and early planning. Child welfare services usually and juvenile justice services usually include services in placement, and a lot of the services that we're going to be looking at for kids as they age out don't necessarily include a place to live. And I think most of us have seen as one of the biggest challenges for transition age youth with disabilities and without is finding appropriate, safe and affordable housing. And so understanding that there's not exactly an equivalent of the child welfare juvenile justice system in terms of it provides you a place to live and services. And then part of being under juvenile court jurisdiction is having the court oversight, and you have a right to an attorney. You have caseworkers and case planning requirements, and those aren't the types of things that travel with you when you transition. And while some of those things can be, I guess, aggravating to people, they do provide a safety net if things are not done, and that's not going to be there in most cases for youth. So this slide isn't meant to scare you. What it's meant is to give you some pause to say, well, what do we do about the things that are going to be lost, and how do we fill in? Because this youth will be losing some advocacy, some oversight, and entitlement to more comprehensive services. And if the youth has a lot of needs, what are we going to do to address that gap? So I wanted to look at kind of a snapshot of one of these big changes that is really important to understand for kids with special needs. So keep mentioning this EPSDT, early and periodic screening, diagnosis, and treatment. It's really a comprehensive and preventive child health program for kids who have Medicaid or medical assistance under 21. It includes the medical screenings, vision, dental, and really does require that kids get what a health professional says medically necessary. Once you turn 21, even if you have medical assistance, and as we mentioned, most kids who are aging out should now be eligible, the EPSDT requirement does not apply. And so there are a lot of limitations and restrictions on services, and so many of the kids you're working with who are getting a lot of services, those services are not necessarily going to be covered under medical assistance as adults. So some of the things that change, just some small examples: hearing aids aren't covered, wheelchairs only once every 3 years, restrictions on number of days that an adult would have a psychiatric hospitals are limited. So if you think of some of your clients who have significant numbers of hospital stays, those kind of stays would not be covered. Some home health care services, including nursing, have a lot of limitations on. So some of you might work with kids who are getting 8 to 10 hours a day, or maybe 24/7 of skilled nursing. That is something that would not be covered under medical assistance as adults. So what do you do? So some of the things that you would be looking at is accessing medical assistance, home and community-based waivers, and then also accessing supplemental security income. I do want to note, because we're going to have, as Megan and I mentioned, we're going to have some webinars both on these Medicaid waivers and accessing SSI. But I do want to point out that in the guide, there are 2 large sections in Section 2 about Medicaid waivers, which start on page 76, and then we also do have a section on SSI. So if you don't want to wait till the next webinar for more detail, I did want to let you know that those are 2 areas that we designated 2 separate chapters for because of how important they are. So I want to start, though, with, before we jump into the Medicaid waivers, is talking about some special issues around youth with intellectual disabilities. And most of you do know, but the term now, most counties have shifted to not using the term mental retardation and using the term intellectual disabilities. So we're following that as well. And so we're going to be using the term ID or IDS to refer to the county agency that's designated to work with individuals with intellectual disabilities. So let's take this quick poll. At what age should a youth with intellectual disabilities be registered with their county intellectual disability agency? Okay, thanks. All right, I'm so happy with these results. It's absolutely true that kids, as soon as they're identified as having an intellectual disability, you should register them with your county intellectual disability agency. Why I wanted to do this quick interlude with talking about registration is that this is one of the areas where actually registering a youth as having a certain disability is really key to accessing a whole array of supports and services, including Medicaid waivers for kids with intellectual disabilities. And many people do think, but it's great, not people on this webinar, think that you wait until they're about to age out. And you really don't want to do that. You really want to register them, and you really can register them from age 3 up. And it's important to do that, to get them in line for these very high demand services, which they may not, it's possible they may not need to access till they do discharge from the juvenile justice or child welfare system, but to make sure that they are in place, you need to register them. Megan, can we go back to the slides? Thank you. And so this is one of the areas where I definitely would encourage, if counties don't have a policy in place, that they do in their child welfare and juvenile justice agencies, or even some of you who are private providers who are working on this issue, that you do have a policy in place of when you want this done, and if you potentially want to have a point person to do it, to either update information about addresses and deal with any correspondences about need for updated evaluations or anything else. I think that just seeing some of these cases kind of run through and kids aging out, it's at least, I think, worth a discussion, because when kids fall through the cracks with registration, it really creates such difficulty, both for the whole systems, for the youth, and these are the cases where sometimes advocates do get orders that the child welfare agency keep the youth past age 21. So this is an area where you can register them, you can do it earlier, so setting up a system is going to help the youth, and it's going to help you as well. Some of the things just to consider: to register a youth, you need IQ scores as well as testing of adaptive functioning, and those are things that most likely will be in your possession, or you can have ordered or request through the managed care organization, but they're things that you want to make sure are available so that you can submit them. You also do want to know that if the IDS agency denies registration, that is something that can be appealed. So you guys who are working with a young person and you really either feel the IQ testing or the adaptive functioning testing was not accurate or didn't reflect their skills, you really do want to appeal that, because again, this registration is really key to accessing a lot of services. One of the things that I hope is useful for people is in the planning tool. I want to show you kind of an example of how we hope the tool is used and will help prompt you to take some action steps. Megan, can I go to, yes, thank you, to the intellectual disabilities. Thank you. So on page 9, the section on intellectual disabilities starts. And what it will do is prompt you to do certain things that hopefully will facilitate you both registering a youth, thinking about a policy for your agency, and also about action steps you might want to take. So this is going to prompt you to ask yourself about evaluations you have, if you've submitted them, and then once you have done those things, kind of addressing what action you take after you've registered. And so again, some of these questions will prompt you to know you need to do something else. So if you're not able to really verify a date of registration, you're going to want to go back and see, do I really have proof that there was registration? If you don't know who the supports coordinator is, that's someone that would be assigned after a youth is registered. That would also lead you to say, well, let me double check. Let me make sure that there's registration, and if they don't have a supports coordinator yet, at least confirm that that's the case. In the manual, as I said, we have a whole section on intellectual disabilities. The PUNS, the priority of urgency of need for services, is a form that the IDS agency fills out just to categorize how urgent the need for services is for the individual. And so one of the reasons that we put this here is important for you guys to know about is that you're going to want the IDS agency to know how imminent the discharge is so they can appropriately categorize the youth you're working with as needing those services. So that knowing that potentially, okay, at 21 this youth will age out and they have nowhere else to go. So to make sure that the urgency of their need for services is known by the IDS agency. Because this is one of the areas, particularly these waivers for individuals with intellectual disabilities, where there are huge waiting lists, and that even people who are categorized as emergencies are on the waiting list. So this is an area where you really don't want to wait until the end of the road, and you really want to make sure you have some communication with that agency so that the need is accurately reflected. Okay. Okay, and so the intellectual disabilities area is the one area where registration is necessary to access these home and community-based Medicaid waivers. But now I want to talk about them as they apply to youth not just with intellectual disabilities, but also youth with autism and youth with serious physical disabilities. And this is a kind of hard concept because many of you work in a field where we talk about waivers for a lot of different things. And this is a very specific type of waiver. And it's something that is in the Social Security Act, something that all states have access to, and they're technically called 1915 waivers. That's the section of the law. And what they do is they basically allow states to address the limitations that Medicaid has to provide the services, the limitations I talked about earlier, and really kind of target this kind of bundle of treatment services to individuals who have very high needs. And so it's really a way to address the gap that adult Medicaid presents for some of these individuals who need more services than are allowed under the current system. So, and they're really targeted, the home and community-based portion of preventing institutionalization. So these are this kind of bundle array of services that are to be provided to individuals with cognitive, developmental, or physical disabilities so they can remain in the community. And as I keep saying, like these are benefits or services that are not entitlements. They're services that an individual wants to establish eligibility, but that there might be waiting lists for. And so, as I said, throughout the guide, or I'm sorry, the guide we have a specific chapter that starts on page 76 that talks about and is going to go through all the different waivers so you guys can have a sense of, well, if the youth I'm working with has a serious physical disability, which waiver might it be? If they have intellectual disability, is there a waiver for them? And it's going to give you the ages when the waivers can start and the contact people and how you start an application. So not going to go through in as much detail these slides, but I want to say, like, if you're working with a youth with a serious physical disability or developmental disability, you want to just have a sense of what do these waivers cover and what might I be looking for as the youth is getting ready to transition. So for example, your youth who has significant physical health needs and is receiving a lot of skilled nursing, you're going to be wanting to look through several of these waivers. Independence waiver, potentially, attendant care waiver. And again, you can consult with us, you can consult with DRN and Health Law Project if you want to have more discussion about, here's the youth I'm working with, what do you think I should be looking at? And we're happy to work with you on that and help you figure out what the application process would look like. And then just going back, the autism waiver is something that does not start until age 21. So knowing that age when that benefit begins is important, because that does bear on potentially the age that the youth is aging out. So if they're going to if they're discharging at 18 or 19, know that the waiver, if they need significant services, is not going to pick them up until 21. So you want to factor that into your planning. Okay. And one thing that is important to acknowledge is that one of the areas where there is not a home and community-based waiver is behavioral health. There are the two waivers around intellectual disabilities, but not behavioral health. So we're going to have a future session on special issues around transitioning for youth with behavioral health. But as we transition to talk about supplemental security income, that's one of the areas where that's going to be applicable to all the youth we're working with disabilities. But because of kind of the lack of more comprehensive transition services for youth with behavioral health needs, SSI is extremely important. And many of you know about SSI and have worked with youth who either are getting it while they're in the system, which is a possibility, but mostly you would be working on the application as they're aging out. And I'm sorry for the typo there. It's $7.10 a month, not months, so I apologize for that. But SSI is a cash entitlement benefit for individuals, children, and adults with disabilities, and it also guarantees medical assistance coverage. That $7.10 a month is really helpful for a lot of reasons. Often, as I said earlier, housing is a big issue, and this can help either help defray the cost of housing for youth who don't have access to other supports or benefits, and might also help in as you're working with the youth to brainstorm a housing plan, them having access to that income might make an option open up that wasn't previously available. For example, a family member who wanted to take the youth in but needed some financial assistance to defray the cost of having an additional person there, that might help. In some situations that might be enough in some areas of Pennsylvania to support rent. It might facilitate a roommate situation, so that's just something that's important to think about in terms of what it can allow to establish a transition plan. So and we do have a whole section on SSI, but just wanted to give you guys a snapshot that for SSI, this is a benefit that has an income eligibility criteria. And so you have to have very little or no income or assets, and then you also have to have a disability. The standard for kids is related to kind of daily functioning, and the criteria for adults 18 and over is interfering with the ability to work. So one of the things we're not going to spend too much time on today, but we'll talk about at the webinar that we'll do on SSI, is that kids in care can receive SSI. Because of how income is counted and sometimes the cost of placement is considered income, sometimes they can't, but there are a lot of situations where they can, and it can, in some situations, help you provide a better living setting or more services for a youth. So I just wanted to leave that, that information out there, but we'll talk about that in more depth at the SSI webinar, but we also have some information in the manual on that. So in most cases, we are looking at accessing SSI as a youth transitions out. And this would be both the juvenile justice and child welfare system. As I said just a second ago, it really can help prevent homelessness because usually those funds are used to help support a living arrangement. And paired with other services, it can facilitate a good transition plan. SSI eligibility might also be a gateway to other benefits that will complete a good plan. So for example, one of the programs we talk about in the guide and we'll talk about in a housing webinar is called domiciliary care, DOM care. And that is a program for individuals with disability that does provide a living setting, but you need to have SSI to be eligible for that program. So SSI is important not just for what it provides, but what it might lead to in terms of opening up options. And there are also a lot of ways, sometimes people think, well, if a youth applies for SSI, that means work is out of the question. And that really is a misunderstanding. There's a lot of ways that youth can pair work and education with receiving SSI, and there's a lot of incentives within the SSI, the Social Security Administration, to incentivize work and savings so that SSI, maybe for some young people, can just be a step to getting them more stability. So you don't have to think about it as an end plan. It, for some youth, might just be a transitional stepping stone to other things, but again, is often really crucial because we sometimes don't have the resources we need to complete that transition plan. So just want to talk about, because usually we'd be accessing SSI when a youth is transitioning, I want to put this to you guys. A youth cannot apply for SSI until he or she is discharged from the child welfare or juvenile justice system. Is that true or false? Excellent. So it is false, but it continues to be kind of confusing because for many years it was required that you could not, or you were prohibited from applying until a youth was discharged from these systems. So some of the Social Security rules changed a couple years ago, and now you can submit an application 90 days before a youth is discharged. And in some cases you actually can submit it before that point, but for youth whose placements, whether delinquent or dependent, are funded by Title IV-E, you might need to wait for the 90 days before. And so I think that it's not ideal. It would be better if in all cases we could do it earlier, and we will talk about at the SSI webinar some strategies potentially for getting around even the 90 days in a more kind of systematic way. But you do know at least that 90 days before you could submit the application. And Megan, can we go back to the slides? And so what we tend to recommend to people is if you are in a situation where you cannot apply until the 90 days before, you will know what the application process looks like and what you need to submit. Is that our recommendation is have that application ready to go and all the documents. Okay, thanks. So what we recommend is that, and the chapter that talks about SSI is going to give you links to the applications and all the things to get you in the position, so that if you need to wait, if you can only submit the 3 months before discharge, that you are submitting on that day, that you are ready, you have all the applications filled out, signed, and you have the documents to submit. Because what is true is that there's various ways to handle the application. You can just fill out the application and fill in all the treatment providers and explain all the impairments, and that's one way to do it. If you really want to try to expedite the process, you're going to submit, of course with the appropriate consents, the documents that support the finding of disability. And the reason that we really advise people to do that is one, that's really going to expedite things, but two, you should have those things. You are in the position, in most of the cases, the Child Welfare Agency is obligated to have those things, those documents in the file. And those are things that you should have and can submit. Again, you want to make sure you have the appropriate consents, but if you actually submit the documents that they're going to be requesting anyway to make the determination, that's going to help expedite the process as well. And there are, in Philadelphia, the Homeless Advocacy Project, and I think Shelley Levy and Laura Colt might be on the call. They have been collaborating with the Department of Human Services to do applications for youth before they age out, and that's been wonderful in really helping establish solid transition plans for youth. And if you are thinking about those, figuring out some partnerships in your county about how to get help to do that, please feel free to contact me and we can give you some ideas. Because it has been a really invaluable way to make this process less daunting and also open up some options for youth who really need this as part of their transition plan. One part, but an important part. Okay, so here's just some examples of some of the documents that you probably have already, but that the Social Security Administration is going to want to evaluate an SSI application. And it really just is the records of treatment and the things that do show how the youth is doing or functioning. And often the IEP and the educational records, particularly if you have some good vocational assessments, are going to be really helpful as well. We often do ask for people who are working with the youth and providing IL services also to write or provide some information of the adaptive functioning, the daily living skills of the youth, because that can be helpful as well. So just consider those things, and again, most of those things are things you have already and can expedite the process. Okay, so before we close, I did want to give everyone kind of a sense of what are the topics we're going to be covering this coming year. So gave a little snapshot of some of the red flags and things you want to worry about and look into in connecting youth with intellectual disability service system. It's clearly a complicated system, and I'm sure many of you have dealt with registration and advocacy in that system, and it can be really challenging. We're going to do a whole webinar on that and have some advocates from the ARC to help us in giving us some tips of how to work within that system and understanding some of the services available so you really know what the youth might be receiving when they leave the system. Again, we're going to talk more at one session about SSI and how you could potentially use it for kids while they're still in the system, and then maximizing how it can be used for transition. We didn't do as much today on addressing behavioral health needs of youth. We did a little bit, but I think what people are most interested in is that transition for kids with behavioral health needs, and we'll have a whole webinar on that. I'm going to focus a little more concretely on educational transition planning and spend more time on specific elements of the transition plan, but then look at college and accommodations plans. Another webinar on kind of how you enhance some of the connections with adult systems in your community so that you can have kind of a more enhanced transition system. Want to do one session on legal strategies, looking at some strategies in court for attorneys in particular, and some things you might want to consider in terms of filing motions and putting on some hearings to support some requests for services. We didn't talk about today legal decision-making issues for transitioning adults, and that we feel like is a full webinar. So for youth who are transitioning at 18 and become their legal decision-maker for mostly everything, if they don't have the capacity to do so, what do you do? There's a lot of areas in the law and a lot of strategies we can use that are short of guardianship, and we're going to do a whole session on that. I mentioned the protection and advocacy system, so DRN and the CAP system, and we want to do a webinar on what they do and how they can help you, because I've found that many child serving agencies don't know about them and think of them as adult agencies, and they really are invaluable resources to figuring out how to access more services for kids and just understanding how the ADA and Rehabilitation Act apply to youth. And we want to focus on housing issues, so I mentioned DOM care. I'm going to talk more about DOM care and some other housing options, and then spending more time on those home and community-based medical assistance waivers. Again, we have a chapter in the guide on these things, but want to do a full session to give people a better sense of kind of what exactly you get when a youth is enrolled in those waivers. Before we close, I do want to see if there are any questions. I know this is a lot of information, but really would love to hear from people if they have particular questions or comments. So I guess if we don't have any, it's my contact information. You can send any comments or questions that you have. And then Megan is, I mentioned that we're going to have another webinar next Monday. Mara McInerney from ELC, who many of you know, and Kate Burdick from JLC will be presenting. And that will be Monday, December 16th from 12 p.m. to 1 p.m. And you can actually click on this very link right now if you want to register. Okay, so it looks like there are a couple questions. Megan, I don't see them. So guys on the line, thank you for being patient with the technical skills. If you can give me one more minute so I can be able to see the questions. Okay. All right. Thank you. And I'm very sorry that this took me time to find these. So, and this is a good question. So, what are thoughts on the application of the ADA's least restrictive setting requirement in the juvenile justice context, particularly when kids are placed in institutions? And that clearly is a more complicated question in the sense that that least restrictive requirement in the juvenile justice and in the criminal context is balanced by other laws, so other law enforcement or juvenile justice objectives. I still think that we can use the ADA even in that section, and I don't think there's been much litigation on that. I think there's been some around services kind of within the prison and not in terms of what is kind of more flexible as a continuum of placement options in the juvenile justice system. So I think that that is something where if you do have issues and ideas of raising some issues, that I think that it is applicable, that it might be more challenging, but I think both Disabilities Rights Network and our office is really interested in looking at those issues, because even though in the juvenile justice system we do have, you know, we have public safety and other principles that we have to balance, we do have rehabilitation and treatment, and so in those areas I think, you know, we still can use both the ADA and the least restrictive requirement, which I believe is supported in both our juvenile justice court rules as well as our child welfare. So I would say I think we can use it in a tool, and definitely contact us about cases where you think it might apply and where you want to use it. And again, as I said, I think DRN has been looking at that as well and would love to talk to people about how we could utilize that. Oh, and so we did get a question about or a comment about the resources of the Office of Developmental Programs and their supports coordination organizations and what they can offer. And you're absolutely right. And what I wanted to kind of give a little information today was some of the red flags in terms of what child serving professionals, both in terms of child welfare and juvenile justice, what you need to look for to connect your youth with the IDS or Office of Developmental Programs. But you're right, and this comes from Deborah, that what we want to do in the webinar on intellectual disabilities is really talk about what services are provided, how child serving professionals can work with the supports coordinators that are assigned to partner and collaborate. We actually have in the manual some good examples where we've seen that be done, and it tends to help the transition. So you're absolutely right. We didn't get to touch on the Office of Developmental Programs and Supports Coordination, and then the organizations that supports coordinators are at, and we will definitely bring those in to a future webinar. So thanks for bringing that up. So what is a difference that we have between currently between the child welfare system and juvenile justice system is some of the transition planning requirement, both in federal law and then in our court rules, as I mentioned, the requirements that require that we have a transition plan before juvenile court jurisdiction is closed. That is currently specific to dependent youth and only covers delinquent youth to the extent that they are dependent as well. So we don't have as many kind of legal tools that require all of these planning for transition for youth who are only delinquent. However, what we do have in Pennsylvania is a lot of work that's being done on improving reentry, and for when kids are reentering the system, the community from the juvenile justice system as older youth or young adults, it is the transition planning. And so what our hope is that a lot of the practices that we're really promoting that are required under the law for dependent youth, that they are really practices that we should be using for delinquent youth. And in the future, if we can get court rules that mirror dependent, I think that's something people would like to do, because these youth have basically the same needs and want to make sure they have access to the same supports. And what I would encourage, and again, in the webinar where we want to talk about developing capacity within each county, I think that's not just about services but about processes, that we encourage people to be developing their transition processes for dependent and delinquent youth, because again, the majority of things we talked about today are things that delinquent youth can access as well, and so we should have processes in place in the counties to have this planning done for both delinquent and dependent youth. But we're definitely on board for working with people to strengthen the transition planning requirements for delinquent as well as dependent youth. And we, all the work we're doing, we want to be used for both those populations, and we're happy to work with anyone to make that possible. So the next question is about SSI and SSDI. And SSI is supplemental security income, and so that is a disability benefit for low-income people based on their own disability. There's a couple of other disability benefits that are either benefits that a youth might get based on a parent's disability, and that is not something we covered, but that is something that someone's asking about and that we can spend more time on when we do. The session that we're proposing for the webinar is to focus on supplemental security income, because that is something that the majority of youth that would be the benefit in most cases we would be focusing on for youth with a disability. But the commenter is absolutely right that there definitely are some youth that we work with that it ends up that we are that they are eligible for a disability benefit based on a parent's disability, and we do want to make sure that youth can access that as well. So that's a good point, and we'll put that on a list of something something to add to that SSI, maybe broaden it to more kind of benefits through Social Security. Okay. So we have a question about which county to register children for which county, which intellectual disability office should you register a youth who might have their placement outside of their county that they are legally committed to. And this is something that we are going to continue to bring to the state's attention, because what we've heard back in our position has been is that you should register them in the county that has legal commitment of them, and that should be the standing practice. However, we have gotten different directions from different people about that. So that made the most sense to us, and was I think I would say the majority position that I have heard. But I think this is something that I would encourage everyone on the line to be asking their ID agency, and also bring to the attention of the State Office of Developmental Programs that we want clear direction on this, because for good or bad, we do have kids that their placement is not in the county that the Child Welfare Agency is, and sometimes that's just because of proximity. It might not be that they're that far away, but they're just across county lines, so it's not necessarily a bad thing. But we've run into that case as well. In most of the cases in Philadelphia County, my experience has been that even if they're placed outside the county, you start the registration with the county where they are committed, and sometimes they will transfer the case, particularly if the youth is really going to end up living in the other county. But this is something we need to work on so people have clear guidance. For the individual who asked this question, if you want to keep in contact with me, I'll definitely work with you on trying to clarify this, because the worst scenario is that people give you different information and don't allow you to register, and the bottom line is we need to at least get the registration started. So please, I think this question is from Laurie, please follow up with me, and I'm happy to work with you on this. But this is an area where we have gotten some different directions. And so it looks like we have 2 questions on that. So my recommendation in the direction I have been given is that you register in the county where the youth is committed, but I definitely have heard some people get different directions and say it's where the youth is physically living. So again, please stay in contact with me if you're having trouble with that, and we'll try to help you with this. And that will be something when we do the webinar on working with IDS, where we really address those issues. All right, well, thanks everyone. I'm sorry I was confused. I couldn't see all the questions. Please continue to feel free to email questions. Megan is going to send out all the documents. And one of the things also to know is, so you're going to get copies of the professionals guide and the planning tool and the youth guide. The planning tool is meant to be an online form, a form fillable, so you can type in your information then print it out. Both guides you can download, but we also have hard copies that we can send you for free. So if you do want to email Megan or I and you want copies, we have them printed and are able to distribute them for free. So just let us know. So if you know, sometimes it's more helpful to have the hard copy to carry around. Let us know, and we're happy to send them out to you. All right, Megan, did I forget anything else?
No, I think that's everything. So
okay.
We'll go ahead and wrap up. Thanks so much, everyone, for coming today. We really appreciate you participating in our webinar today. Thanks so much.